Hello and welcome to my presentation. I have chosen Reform to Mortgages because it is a very nice topic and I did it for my exam. There were many other topics I could have chosen, for example Travellers on Greenbelt Land, HS2, Heathrow's Third Runway and Ownership Rights in Cohabitation. In the words of Lord Diplock in Pettit and Pettit 1970, the UK is a property owning democracy. This is because many people have aspirations of owning their own property. However, land law is designed to essentially stop you from doing something. For example, the mortgagee violently entering one's property. I will be arguing that the mortgagor, the person who borrows the loan, should be given more protection. Cohen et al. Argue that mortgages are the bread and butter transactions which have enabled over 70% of the UK's population to become homeowners. Nicola Jackson argues that approximately 3/4 of house purchased are financed with a mortgage loan facility. Suzanne Smith believes that homes are a hybrid of money, materials and meanings. Under Section 27 2F Land Registration Act 2002, a charge by legal mortgage is a triggering event. Under Section 41G Land Registration Act 2002, the mortgage must be registered. Under Section 85(1) Law of Property Act 1925, a mortgage is a fee simple by grant of long lease 3,000 years to mortgage. Under Section 87(1) Law of Property Act 1925, the lender gets the same powers as if they own it outright. It is possible to have an equitable mortgage by having an enforceable contract that complies with Section 2 Law of Property Act 1989, or a written mortgage made by no deed or even a defective deed under Section 2 Law of Property Act 1989. However, an equitable mortgage by deposit of title deeds is no longer possible, as shown in United Bank of Kuwait Public Limited Company and Shahib 1996. A mortgagor has the right to redeem by paying off the mortgage with interest and releasing the land from the mortgagee's charge. A mortgagor also owns the equality of redemption, and equity has laid down the fundamental principles for this procedure to be carried out, where there must be no unfair or unconscionable collateral advantage for the mortgagee, as shown in Noakes and Company Limited and Rice 1902. In this case, Lord Davey said that once a mortgage, always a mortgage, and nothing but a mortgage. Also, the doctrine of undue influence, fraud and misrepresentation was strengthened in Barclays Bank and O'Brien 1994. Lord Wilkinson said that unless the creditor who is put in an inquiry takes reasonable steps to satisfy himself that the wife's arrangement to stand surety has been properly obtained, the creditor will have constructed notice of the wife's rights. In Royal Bank of Scotland Public Limited Company and Ettridge No. 2, 2002, the court ruled that they must consider whether the law strikes the right balance. Despite this, the right to take possession of a mortgaged property is an inherent right for the mortgagee by virtue of Section 87 Law of Property Act 1925 and in 4 Maids Limited and Dudley Marshall Properties 1957, the judge so famously proclaimed that the mortgagee may go into possession before the ink is dry on the mortgage, unless there is something in the contract, express or implication, whereby he has contracted himself out of that right. He has the right because he has the legal terms of years in the property or its statutory equivalent. I believe that this inherent right to possession should be restricted and curtailed. Under Section 36(1) of the Administration of Justice Act 1970, this is a lifeboat for the mortgagor who wants to stay in his or her property. Under Section 36(2), the court can adjourn possession proceedings if the mortgagor is likely to be able within a reasonable period to pay any sums due under the mortgage. I believe that the courts should not use an objective test, but rather a subjective one. I believe that the decision in Ropage, Latch and Barclays Bank Public Limited Company 1999 should be reversed because it leaves the mortgagor in a very vulnerable position. For here, the mortgagor fell behind on his mortgage repayments and the mortgagee sold the property in auction. The Court of Appeal ruled that bank had the power to take possession this way because Section 36 could only take place if there's proceedings, and there wasn't any proceedings in this case. Even though the Council of Mortgage Lenders stated that its members, the vast majority of them are UK banks, will not sell any owner-occupied residential properties while the mortgagor is in default without first obtaining a court order for possession. This is obviously a positive thing. However, banks are not obliged to join this council and they can opt out whenever they see fit. Also, Sarah Neal suggests that banks should look beyond their own interest and take the mortgagor's interest into account. It could be argued that banks are only concerned with getting their money back. I believe that there should be a law which states that a lender cannot sell property to him or herself, an associate or associated company, and if they do, then the sale must be set aside. In both Tees Kwong Lam and Wong Chit Sen 1983 and Colbert and Halifax Banking Society 2003, this principle was breached, but the court strangely did not set aside the sale, instead awarded damages, and I believe that this law should be brought in to set aside sales which breach this principle. I believe that there should be a law also in place which stops banks from putting a very high interest rates on mortgages. And also, since foreclosure is a rarely used draconian remedy, it shouldn't be available as a remedy to the lender. This is because lenders dislike it, since they are prevented from suing. Also, courts can order sale instead of foreclosure under Section 91(2) of the Law of Property Act 1925, and this idea was reinforced in 20th Century Banking Corporation Limited and Wilkinson 1977. I believe that the Secured Lending Reform Bill should be revived and passed through Parliament as a matter of urgency, because that way it will give the borrowers, the mortgagors, more rights and more protection. And this should be one of the new Prime Minister's Theresa May's aims, along with Brexit. And to conclude, I believe that my reforms will not lead to a financial crisis witnessed in 2008. As you can see, there's a picture of Lehman Brothers. When they collapsed, that started the 2008 crisis, because people are more wiser and they are more cautious now than in 2008. Mortgages are terribly important, and as the saying goes, an Englishman's home is his castle. Thank you very much for watching.